Welcome to the Land to Lots podcast, powered by Launch Development Finance Advisors. And now your host, Carter Froelich.
Hello, everybody, and welcome to the Land to Lots podcast. This is Carter Froelich, and it's great to be before you again here today. And I've been waiting for this podcast for a long time. For some of our listeners, you know that we've been actively involved in the review and critique of development impact fees for the private sector for over 40 years. And today I have the distinct pleasure of welcoming to the podcast Paul.beard. And Paul is a partner with the law firm of Pierson Ferdinand. But more importantly, Paul has argued two of the most important, at least in my mind, Supreme Court cases related to development impact fees. The most recent being Sheetz versus El Dorado County, and prior to that, Koontz versus St. John's River Management District. And we're going to get into the specifics of those cases, focusing primarily on Sheetz versus El Dorado and the implications that has as it relates to us. All of us, primarily our listeners, are involved working with the private sector in the provision of infrastructure and quality master plan communities. But with that as a high-level introduction, Paul, welcome to the podcast.
Thank you very, very much, Carter. It's a pleasure to be here.
And Paul, before we get started, could you tell our listeners a little bit about yourself, your background, and then most importantly, why this area of law?
Sure. So I am in practice now for about 25 years and based in California. And went to college at UCLA, went back east to law school at Cornell. And then when I graduated, I actually started off at a large firm, Latham and Watkins in Los Angeles. That soon became clear to me that was not the kind of work that I wanted to do, which was kind of general commercial litigation. And so a few years in, I moved up to Sacramento to work for the Pacific Legal Foundation, which, as many of your viewers may know, is a nonprofit legal foundation that specializes in bringing precedent-setting cases that promote and protect private property rights.
Yep.
And so there, I got my feet wet in property rights and did a lot of property rights cases. A lot of them were being brought against the California Coastal Commission, which is a state agency in California that regulates land use along the coast. Very abusive agency, probably one of the most abusive in the country. And so I got my feet wet there and spent about 11 years at Pacific Legal Foundation. And towards the end of my career at Pacific Legal, I was fortunate enough to take over a case in Florida that had been litigated by private attorneys there. The plaintiff in that case that was suing a state agency had run out of funds, and so we took over that case. That's Koontz versus St. John's River Water Management District, which I'm sure we'll get into. And then from there, I argued that case in 2013, and the decision came down favorably for us. And so from there, I moved into private practice, first at Alston & Bird, which is a national law firm practicing environmental land use law, and then finally landed here at Pierson Ferdinand, where I still do land use law. So mostly permitting and litigation. I help applicants through the permitting process, and then I sue the government when they do bad things, which is in California quite often, actually. So they keep me in business.
And so our listeners are probably wondering, why the hell is Carter talking to Paul, and why is Paul talking to Carter? And so let me just go back and remind all of our listeners and Paul, for to the extent it's helpful for our conversation. But I was UC Santa Barbara graduate, so we're kind of related, but started public accounting and ended up in Orange County working with Kenneth Leventhal. And during this time, we started putting together community facilities districts in the early 80s, building infrastructure for which some of the jurisdictions were collecting development impact fees. And to ensure that our landowner clients weren't getting double dipped, meaning we were paying for infrastructure from the CFD and then a second time through impact fees, we were determining what our impact fee credit should be. And being the good accountants that we were going through and looking at the fee studies and tying them back to the CIPs. We were adding up to, math, footing and cross footing and redoing the calculations. And we found, you know what? These numbers don't tie to the CIP. There's mathematical errors within the calculations. And if we correct all of these items, then we will lower the fee by about 25%. So that's how we got into working exclusively for the private sector to review municipal development impact fee studies. And I also then was assisted the National Home Builders Association prepare their 2008 and 2016 impact fee handbook, and we just recently updated it for 2025. So we work in the same arena as Paul. And Paul, I have read about the Koontz decision forever, and then recently the Sheetz. So before we jump into Sheetz, let's just talk a little bit about some of the concepts we're going to be discussing here today, and that's the whole idea of rational nexus and rough proportionality, and then we'll talk about Koontz and Sheetz. If you wouldn't mind giving our listeners high-level description of what that really means in the context that we're speaking here today.
Absolutely. I'll try to give the 30,000-foot view, and then you let me know, Carter, if I should fill in any gaps. The concepts we're talking about really apply in the context of land use permitting. So a developer needs a permit to build or improve or maybe repurpose the use of his land, needs to go to a government agency for authorization to do that, pulls a permit, and the government says, we'll give you a permit to build or to make another use of or improve your property, but first you have to give us something in return. So it's kind of what I would characterize, I'm a part of the property rights bar, and so I don't look kindly to these kinds of demands. And so I would call it, kind of extortionate, really is what it is. You need a permit, it's worth millions to you maybe, but we're going to get something in return because we can. Mm-hmm. So that's the context in which these concepts arise. Now, every state has its own, including California, has its own standards and legal principles to control the government. But above those standards is the federal constitution, which is what really I deal in. Mm-hmm. The federal constitution has a takings clause that says the government can't take your property without compensation. And so that is kind of the linchpin of these cases. Mm-hmm. When is the government going beyond just requiring you to mitigate your bad impacts arising from your project, and is instead just using the permitting process to leverage something of value from you? The federal constitution, starting in 1987 with a very famous case called Nollan versus California Coastal Commission, that's Nollan. Starting then, the U.S. Supreme Court started to impose limits through the takings clause and said, look, yes, government, you have broad police powers to offset, to mitigate adverse impacts that arise from a project, but you cannot take private property without compensation. So in the Nollan case, for example, the agency there, the Coastal Commission, was trying to take an easement across a public access easement in the backyard of a property owner's land in order before giving him a permit to rebuild. And the Coastal Commission said, no, there is no essential nexus there. In other words, there was nothing about that rebuilding of a bungalow to a single family home that was causing impacts that would justify the government in demanding a public access easement. Mm-hmm. And so there the court said this is just an out and out, quote, plan of extortion. So there begins really the framework of the cases that we're going to discuss. You have Nollan in 87 saying there has to be an essential nexus. In 1994, the U.S. Supreme Court took on another case out of Oregon where it clarified that not only do you have to have a close enough relationship between impacts and what the government is demanding, but it also has to be roughly proportionate to the impacts. So you've got then the essential nexus test, you've got the rough proportionality test. Again, and I repeat, these concepts arise under the US Constitution. So they provide really a floor of protection for property owners, developers who find themselves in the land use permitting context. So that's kind of the nuts and bolts of the concepts that we're discussing today. Carter, do you think I missed anything?
No, I think that was great. Yep.
Okay.
And I think what we're at some point I'd like to drill down more into, what proportionality really means. Yeah, and we're going to talk a little bit of cost, but before that, so for our listeners, you're going to be hearing this a lot. Nollan, Dolan, Nollan 87 relates to the rational nexus test, meaning there has to be a causation there. I think that's right. Forgive me, Paul, because I'm a CPA dealing in your world.
You're doing fantastic. No, that's exactly right.
And then Dolan in 94, which is if there is a rational nexus, then the fee or that you would be paying has to be proportionate to the impact you're having on, in my world, infrastructure. So far so good, Paul?
I would just make one caveat so that we don't get ahead of ourselves too much. Nollan and Dolan both involved the government trying to exact an interest in real property,
Sure.
an easement,
Okay.
Conservation easement, open space easement, land. And so there was no question in those cases that was a taking of private property that the government could not justify. Later cases, or a later case, Koontz then dealt with the question of money, fees. So I just wanted to make that clear that the drama, this drama goes, has an arc, right?
Yeah.
And really the moral of the story here, and I think developers who are listening will kind of appreciate this. The US Supreme Court comes out with one great case in 87, Nollan, and establishes the essential nexus test. And it's kind of like a game of whack-a-mole. The government takes that decision, tries to restrict it to the very facts of that case, and then tries something different. US Supreme Court has to intervene in 95 to say, well, even if there's a relationship, you can't ask for the world. There has to be rough proportionality. The government takes that, and for years, Carter, 20 or so years, governments across the country are saying, well, these cases just apply if we're demanding an easement. It doesn't apply to money.
Okay.
So that's where we get into Koontz. I just kind of wanted to set that up.
Great segue. So now let's take, we have Nollan, Dolan, now Koontz, and I think that was what, in 80, or wait, what year?
That was in 2013.
2013. So if you could describe what happened in the Koontz case to get us to the money, from land to money.
Sure. So in Koontz, you had a developer, a small developer. He owned something like 15 acres of wetlands in Florida. Now, Florida is kind of divided up into different water districts. These are state agencies that regulate the use of land that is a wetland. And so in this case, the property was in the St. Johns River Water Management District. He had to go for a permit to the district to allow him to build on 3.7 acres of his 15 or so acres of land. The district came back and said, nope, we're not going to issue you a permit unless you first agree to subsidize improvements to wetlands that we own miles and miles away. And so the question then became, well, what's the relationship here? Why is he having to pay so much money to finance government improvements of wetlands miles away? He took his case up through the Florida courts. And in effect, there were two rulings that your listeners will be interested in. This is now in the Florida court. Number one, the Florida courts held, well, Nollan and Dolan, we're going to limit those to cases where the government approves a permit with conditions. Here, the district didn't approve anything. the hearing, what the district said is, we're not going to say yes or no. You first have to agree to submit to our demands before we even issue you a decision on whether
Oh my
we
God.
approve or deny.
Yeah.
So we won't approve unless you agree. And so the Florida government entity there had argued that that's a different kind of case. And so the Florida Supreme Court ultimately went up to the courts, and Florida Supreme Court said, yeah, Nollan Dolan doesn't apply in that situation. The second ruling, the one that is more interesting of the two, I would think, is that the Florida Supreme Court agreed with the government, the water district, that Nollan and Dolan only apply in the cases where government is trying to exact an interest in real property, an easement, dedication of land. It doesn't apply to financial obligations, the conveyance of money, or the conveyance of a fee to the government. And those two issues kind of reflected a split across the country. Some states, I think like Texas, for example, went the other way. Florida went the opposite way. And so this kind of split among the states created just the kind of case that the U.S. Supreme Court likes, which is to resolve these confusing splits among jurisdictions. And so the U.S. Supreme Court took up the case in 2012. We briefed and argued it in 2013. And on both issues, the U.S. Supreme Court reversed the Florida Supreme Court, holding, number one, doesn't matter how the government frames its condition, whether it's we won't approve unless, or here's your approval with conditions, doesn't make a difference. That kind of a condition is still subject to the heightened scrutiny under Nollan Dolan. That's number one. And number two, that Nollan and Dolan apply even to financial obligations, the payment of a fee or the payment of money to the government. So two big wins. I have to say the decision was split. So we had a 5-4 on the issue of whether money fees are a protected interest under the U.S. Constitution, with 5 justices saying, of course it is. Money is fungible. It's like land. It's a taking, and the government can't do it unless it can show an essential nexus and rough proportionality. 4 of them decided that money is not protected.
And I'm just real curious, why would it not be protected in that type of circumstance? I'm just curious with that.
So the big issue that the dissenters had in allowing Nollan and Dolan to apply to money takings was that it feared that it would open the door to litigation over taxes, user fees, other kinds of monetary obligations that in theory, I would argue that they're kinds of takings, but the court doesn't want to open the courthouse door. So how did the majority respond to that objection? The majority said, look, we're only talking about a very unique circumstance, the land use permitting context. We're only talking about financial obligations that are operating on the ownership and use of land. And so it tried to distinguish, I think it did so successfully, it tried to distinguish land use exactions that take the form of fees, money, and other financial obligations from taxes and user fees, which are different kinds of financial obligations that are not subject to Nollan and Dolan.
Makes complete sense. So we had Nollan, Dolan, land into Koontz, which is now monetary issues as well. Now we get into the Sheetz versus El Dorado County, which you argued as well. Could you give us the backstory on that and the importance of the court's findings on Sheetz?
Sure. So going back to this metaphor of playing whack-a-mole, right? The government's, it gets it dinged in one area of the law, or in one decision of the U.S. Supreme Court, but then finds ways to kind of get around. And many courts, like the California courts, they play along, of course, with the government entities and try to find ways to limit Nollan and Dolan's reach. This is another example. So the question in Sheetz is, does it make a difference whether the exaction, now again, this could be an exaction of a real property interest, like an easement. It could be an exaction of money. Does it make a difference whether it's an exaction that was enacted by a legislative body in an open hearing with an opportunity to be heard,
Mm-hmm.
or whether it's an exaction that is imposed over the counter by a building official who says, you know what? Yeah, we'll give you the permit, but first you have to pay us $100,000 to help finance a school down the street that's in disrepair.
Sure.
So the question is, does it matter which government actor is doing, it has created the exaction?
Mm-hmm.
Now, we'll take a step back here because California, as is always the case, it seems, what was a trailblazer in holding that legislatively enacted exactions are protected against Nollan and Dolan.
Mm-hmm.
We have to defer to legislative judgments about exactions and what the community needs in terms of developers financing public projects. And the reason that the California Supreme Court in particular and other courts viewed it this way is that they would argue this way. Look, with a legislatively imposed exaction, you've got, let's say the County Board of Supervisors. It gives notice to the public of what it plans to do. It has a rate schedule. It gives developers the opportunity to come into the board hearing and protest and object. In other words, it's an open, public, transparent process, and the democratic process will protect developers against excessive fees. I'm glad you're laughing at this idea because I think it's laughable.
Yeah.
I mean, a lot of developers, by the way, come from outside the jurisdiction.
Yeah.
And so really, can developers outside a jurisdiction hold that jurisdiction to account if it imposes excessive fees? Of course not.
Yeah.
So boards of supervisors, city councils, other agencies, they tend to pander to their constituencies. And if they can offload a lot of these costs to individual developers and not have to raise fees and taxes on their constituencies to pay for public projects, they're going to do just that.
Right.
So this whole idea that the democratic process, the legislative process, is especially protective of developers, I think is a total farce. I think that the U.S. Supreme Court, as we'll discuss in the Sheetz case, saw through that argument. But that was the argument that prevailed in California and other jurisdictions that, look, if it's legislatively enacted, you can see it in an ordinance or in a rate schedule, developer has notice of it. We're not going to examine the exaction under Nollan and Dolan. We're not going to ask whether there's an essential nexus and proportionality. We're going to defer to the legislative body. All right. So on the other side of the ledger, Carter, are those of us who say, doesn't make a difference who imposes it. An exaction is an exaction.
Yep. Now, when we say in keeping it to California just for right now, so AB 1600, would that be the California legislative statute that allows us the Mitigation Fee Act for the jurisdictions, counties, cities, etc., to enact an impact fee to offset some of the costs caused by new growth?
That's right. The Mitigation Fee Act is an example of a state statute that authorizes those kinds of fees, but the problem is it's not protective enough.
Yeah, and so I'm going to stop now, Paul, just to tell you a little bit about my experience working from California, but this is it goes all over the country. And I think my clients generally believe that if we're causing growth within a jurisdiction, county, city, count, we should, we're happy to pay our fair share of those costs, and whether we're building it or the city's building it and we're paying the city, the county, a water district, etc. And we're happy to pay our fair share, provided it's fair and equitable. And then the question becomes, what's fair and equitable? And we have seen just complete, some cities are good to work with, others not so much, meaning they don't have real costs set up for, they haven't had an engineer develop their costs. Where'd you get the cost for that fire station? Oh, just got it from the town right next door to us, built a new fire station. It was $25 million, and so that's the cost of our new fire station. when that fire station, the existing levels of service may be 2-bay steel buildings. Now they want the new growth to pay for a $25 million fire station with sleeping quarters, weight rooms, and an espresso machine. The two aren't similar. I mean, that's kind of a blatant example, but it's not uncommon to see this. So we have been very, very active in Arizona, New Mexico, North Carolina, going back, working with the private sector and the building industries to make the process more detailed and more transparent. Because anytime we brought up an issue saying, you know what, you had a math error, or your costs are not reasonable vis-a-vis recent construction projects that have occurred, they said, we don't care, sue us. Literally, we don't care, sue us. And so our representation always has been, if you're going to fight a city, we can try to talk reason, but more likely than not, at some point, you're going to have to decide if you're willing to sue them. Thus, call Paul.
Right.
Billboard. So anyway, that has been our experience. And as it relates to the recent conversation in Sheetz, and I'm going to get into AB 1600 in just a minute. What has been the immediate, well, first of all, what is the status? Because I think the Supreme Court just remanded the decision. They didn't invalidate the impact fee. They remanded it back to the lower courts. Is that correct? Or could you just tell us, what the current status is of Sheetz, and then
Sure.
we'll dig into it, the details.
Sure. So the question that we presented to the U.S. Supreme Court was, again, whether there's a difference between legislative exactions and administratively or ad hoc imposed exactions, right? And the court answered that question and said there's no difference. They're all subject to Nollan Dolan. Remanded, as you said, back to the California Court of Appeal. And the Court of Appeal asked for additional briefing on the question of how does Nollan Dolan apply to this particular fee that was imposed on Mr. Sheetz, and what's the outcome? Is it invalid or is it not invalid? And so that issue has been briefed, and there's an oral argument set for June in Sacramento before the Court of Appeal, and then we'll get a decision presumably in the following 90 days. And so we'll have a resolution hopefully by the fall, and then depending on the outcome, there may be more litigation, but that's kind of the time frame and context of where we are right now.
Okay. So you and I had a chance to talk briefly, and I just want to talk a little bit about AB 1600 right now, because in my past life, be it California or other places, we need to set the bar to what are existing levels of service within a community, and then have new growth pay for their fair share of this existing level of service to expand it into the areas that are currently growing. And with that, we can show, yep, and there is a nexus there from Nollan, and you're paying for the existing levels of service that community is currently providing, so it's roughly proportional in Dolan. Here again, this is CPA talking law. Take it for what it's worth. And that's when we would go in and look at those items. As long as we were building the existing levels of service, everybody, at least that we were representing, was fine with it. In other instances, the city would come in and say, our existing levels of service is a 2-lane road. Okay. No curb gutter, nothing. We are going to a new level of service, which is a 4-lane road, divided median, landscape, curb gutter, and public art on the west side of the road. And
the wish list.
True example. And then we'd say, well, that's great. However, your existing levels of service is 2 lanes. And they said, well, we are in the process of changing everything, and we're only charging you for your pro rata share of these new roads. We will be financing this through multiple different sources. Yet they've never had to prove up, nor has anybody ever gone back to prove that they contributed their fair share to build this 4-lane divided median landscape with public art on the west-hand side. And so new growth has been forced to pay for their fair share of a larger level of service than that which was currently existing. So with the transformation that's happened from Nollan, Dolan, Koontz, and now Sheetz, all, getting in a lot of different legal aspects, but still getting back to the nexus and rough proportionality. And now I'm going to go back to AB 1600. And when you look at a specific portion of the code, 6601G, it says that, and I'm going to quote this: a fee shall not include the costs attributable to existing deficiencies in public facilities, which is pretty common around the country, but may include the costs attributable to the increased demand for public facilities reasonably related to the development project in order to, 1, refurbish existing facilities to maintain the existing level of service, or number 2, achieve an adopted level of service that is consistent with the general plan. Now, this is all California code, but in my understanding of California general plan law, the general plans don't have to put forth a funding source on how this new infrastructure is going to be financed. So my concern, and here again, Paul, I hope you don't mind me getting some free legal advice, has always been for our clients is that the cities always come back and say, well, we're going to be building this new levels of service, yet they don't have any way to show how they're going to pay for it. So it looks all good on paper. I call it the wish list, and they're wanting new growth to pay for their wish list, for which they haven't demonstrated how they're going to pay for it. So is that still is there an issue with Nollan Dolan on this, or am I making things up?
No, I think in reading this section that you quoted, I think it's consistent with Nollan and Dolan, except for that last piece, in order to achieve an adopted level of service that is consistent with the general plan. I think if a city or a county or a state tried to force a developer to finance some future wish list of goodies that had no other financing, but they did it just because they had the developer, where they wanted him, which is he needs a permit. I think that violates Nollan Dolan. Nollan Dolan is very clear in my mind that the fee or the financial obligation has to be very closely, even more closely than state law, the Mitigation Fee Act requires, very closely related to the actual adverse impacts caused by the project.
Yeah.
And so, it's in the statute. And if a land use lawyer, were challenging a fee under, and the city said, well, look, but we're able to charge for, future adopted levels of service that we want, that lawyer would do well to focus not on the Mitigation Fee Act and what it authorizes, but on Nollan and Dolan and what the federal constitution require. Because as your audience probably is aware, the federal constitution, the state statute can say whatever it wants, but the federal constitution trumps what the state statute purports to authorize. So I see a real problem there, Carter.
Yeah. And I wasn't sure if I was making things up or hallucinating.
No.
But and that's why I wanted, I was really looking forward to this. And guys, this wasn't scripted. This could have gone very badly. Could have gone the other way. And you said, but I'm not trying, but it's a concern. And when we're looking at whether we're in North Carolina or we're in California or Arizona, it's always Nollan, Dolan, Koontz, and others that relate to.
That's the first place you go.
Equitable.
Yeah.
And I think that's the development community is, we want to work collaboratively with the cities. It's just that my experience in 40 years is we have been taken advantage of dramatically.
Absolutely.
Because they can. And that's the only reason.
Well,
Yeah.
and because it's unpopular to raise fees
Yeah.
and taxes on local constituents, right?
Yeah.
It's just
Yeah.
not politically feasible. It's easier to offload those costs onto a developer. So
Yeah. Yeah. And
politically, you understand why it happens, but it needs to stop.
yeah, I agreed. And it's just been one of the things that I've been very, very passionate about throughout my career. So we've got the sheets going back to the courts in June. Have you noticed, have you heard anything via the grapevine on how the public sector has been reacting to sheets, especially in California, but maybe over the country?
Well, I don't have any personal knowledge as to whether cities and counties are going back to the drawing board and tightening up their fee schedules or their demands. But I am hearing from, I work opposite a lot of city attorneys and county
Yeah,
council and state
yeah,
agency council. And I am hearing that the Sheetz decision came down like a hammer to them. And
yeah,
it sounds like they're taking it seriously and
yeah,
making sure that every exaction satisfies Nollan and Dolan. Whether they do that in the long term is a different story. But aside from whether the cities and states and counties are doing something proactively, I can tell you from personal experience that it's been a lot easier to challenge fees. So
yeah,
I'll get a client come in the door and say they're forcing me to pay $300,000 in affordable housing fees in order to get a permit to build residential housing. And we've been able to get refunds with very little resistance, I think,
yeah,
because it's now become clear to them that the U.S. Supreme Court is taking this issue very seriously.
yeah,
So I think it's making challenges easier, but I've not seen kind of refurbished, impact fee schedules and the like. I'm sure they're out there, but I've heard that they're being developed. But I think Sheetz was an important nail in the coffin of this whack-a-mole game that they're playing.
yeah,
So
yeah.
hopefully we'll see some change over the next several years.
Hey, Paul, I'd like to have another, just focus on the
Sure,
affordable housing fees. That's a whole other
it is.
mind-blowing, just,
Yeah.
oh my God. Yeah, what are we going to do with this? But the uh, so the public sector is waking up. They understand they have some issues. Let's say, for instance, I'm just making this up. I'm doing an age restricted community, in and let's just talk about the Nolan Dolan constitutional issues. And within my community, I'm being charged a traffic fee based on your standard kind of uh, and I know a lot of the cities have active adult traffic fees
Categories. Yeah.
categories, but I guess the point I was trying to make is if I'm a developer and the specifics of my project are such that I could go to the city and say, you know what, we have a town center, we have active adult, we have a lot of our traffic will not be getting out on the major collectors and arterials of the city because why? They're going to go to the grocery store, they're going to go to the town center, which is all housed within the middle of our project. Therefore, our traffic counts should be dramatically different than what you're charging us for. Could, with all of the findings that we've had in Nolan, Dolan, Koontz, Sheetz, could we argue specifically that the jurisdiction should be looking at a fee specific to our project? Or would it ultimately fall under the broader, let's assume it's a legislative imposed city council jurisdiction fee based on state enabling statutes? Would one have an argument for that or not, in your opinion? And I know that's just the facts
I think,
matter, but
yeah, I think, Carter, that is a terrific follow-up question to
mhm,
Sheets. There were some concurring opinions in that, so the court was unanimous about it doesn't make a difference whether it's legislative
yeah,
or administrative. But there were some differences of opinion as to how close a fit you need in the kind of classic traffic impact fee study, say.
yeah, yeah,
And so I would argue, not surprisingly, that there is a good argument that
Yeah.
Each developer of a particular project is entitled under Nollan and Dolan to challenge an impact fee as applied to that project.
Yep.
Um, I think it's there in Nollan. I think it's there in Dolan. I think it's in all of the cases that there is a reason to do that.
Yeah.
I think a second best position might be second best from the perspective of the property owner, the developer, might be, well, as long as you categorize this correctly. In other words, it's not as if the city, for example, has to do an impact study with respect to each project, but maybe it can clump projects into categories and say, well, senior housing projects have these kinds of impacts, and then commercial has those kinds of impacts. And as long as those studies are done correctly and your project falls into the right category and is treated as such, I think it would be more difficult to make that kind of a challenge.
Yeah.
So, but that is an open question, I would say, legally. And there's going to be some litigation on just how refined the city and the county has to make their fee.
Yeah. And I see the engineering community and the cottage industry that's grown up, just working with the jurisdiction.
There's a cottage industry.
Yeah.
Oh, sure.
Yeah. And I've got to tell you, before anybody really knew who we were, and we would go to the development impact fee meetings. Okay, they would hold conferences around the country, and no joke, they would say, and most of the people were representative of jurisdictions coming to hear the impact fee consultants, and the impact fee consultants are, we can get you the impact fees that you want, and
what for a cut of something? I mean,
well,
menacing.
Yeah, and it's kind of like the
like the mafia.
or made as instructed, the MAI, and here again, guys, don't call
Interesting.
me. Yeah, made as instructed. That was kind of during the SNL crisis, but once they found out who we were, and we were just in the back writing down all of their little secrets on how we were going to go, fight them on that, but. They no longer have those fees and or conferences, and they're no longer saying that. And I have great respect. I work with a lot of these guys.
No, we're just teasing.
Yeah, but we still want to be treated fairly, and everybody wants to be treated fairly. And I think, Paul, you and I are on the same. We're happy to pay our fair share as long as it's fair and equitable. But boy, when it's not, I mean that's when it's call Paul. And rather than call Saul or Sal, call Paul.
And it rhymes too. Easy to remember.
Yeah, that's great. Paul, is there anything else that we should have talked about as it relates to these issues here today? I mean, there's probably
I guess there's one other thing that really has come up, even before Sheetz, but I get a lot of calls from developers about challenging different kinds of fees that have been imposed. And, typically my advice is let's go for the low-hanging fruit. And just so your audience understands, a school impact fee, for example, or even a traffic impact fee, those are challengeable, but generally less easy to challenge than, say, an affordable housing impact fee. Or a public art and public spaces fee, something that is just utterly unrelated to the project, right? Affordable housing, which we kind of briefly talked about, really kind of infuriates me because they're imposed on the very developers who are supplying the market with more residential housing, and then the city is saying, and you're the cause of the lack of affordable housing. I mean, basic supply and demand tell you that the more the more housing there is in an area, more affordable it becomes. And yet they're being charged an affordable housing impact fee. And so that drives me nuts.
Yeah.
And, but those are the kinds of fees that I enjoy challenging because we haven't had a lot of cases, not at the U.S. Supreme Court, certainly, that have talked about those kinds of fees. But, I think the takeaway is Nollan, Dolan, Koontz, and Sheetz, they're great cases. They really kind of solidify the right of property owners and developers. But there are still some fees that are easier to challenge than others. And so keep an eye out for those fees that make you scratch your
Right.
head and say, what are these fees why are they listed in these conditions?
Yeah.
They
Yeah.
just don't make any sense.
Absolutely. And Paul, if somebody wants to get a hold of you, how's the best way for them to contact you with any issues they may have with their project?
I love being contacted by email. So if anyone needs to contact me with a case or an issue that they want to challenge, they can contact me by email. If it's something urgent, of course, they're free to call me as well. I think you'll have that information in your notes probably. But just for the record, it's paul.beard at pierferd.com, and that's PIERFERD.com.
Great. And to our listeners, I'll have all of Paul's contact information, email, and phone number in the show notes should you want to get in contact with him. And Paul, I just want to say thank you very much for taking this time. This has been really helpful for me. And if you would like to come back, I'd love to have you as we talk about affordable housing fees. And
It might be a good show in and of itself.
I agree.
Yeah.
And
well, thank you, Carter.
Yep. You're welcome, Paul. Thanks very much.
It was a delight
today.
Okay.
You have been listening to the Land to Lots podcast with Carter Froelich. Follow us wherever you find your podcast to never miss a new episode.